welcome, Paul. We've got Paul Wayburne on air today with us, and Paul is a ex-South African lawyer. He's been based. How long have you been based here in the States, Paul?
So I moved to America in 2016 with my family. Um,
Okay.
I
Wow.
became a California admitted attorney in 2020, and I've been working principally in immigration law since then. Um,
So that's a what, 9 years now?
it's about 9 years. Yeah, I
Yeah.
worked for I worked for a certified specialist in immigration law, um, and then I went on my own, and I've been doing immigration law mostly. I've been doing a little bit of personal injury and estate planning, but immigration law is my passion, and it's what I want to grow my business in.
Good. So that's your forte, Paul. You and I met on. I think we met on online on Facebook because you are contributing to a group called South Africans Immigrating to the US. And first of all, I just want to say thank you for your contributions there. It's always welcome and it's much appreciated. And over time, I've just gotten to know Paul a little bit better, and we deal with some of his IT for his business. But what has always impressed me about him is he's knowledgeable around the topic of immigration, specifically family immigration. He does a lot
That's
of work
correct.
in there. And I thought, let's get you on the air today and let's just ask some questions because, I'm pretty sure you've come to know as well that, every situation that people have is different out there. There's not one cookie cutter solution for every person. So I wanted to bring you on here so that we can ask some questions and just maybe if there's someone out there that's listening that needs a little bit of advice or has been wondering about where they start, this podcast might be a good place for them, right?
I hope so. That's the plan.
So tell me about what are some of the most interesting questions that you get? You must get a lot of questions out there. What are some of these questions that you
Um,
get?
I mainly get questions from people who are married or want to get married and live in America.
Okay.
Usually, there's an American citizen spouse involved, or American citizen parent, or an American citizen child. And so, if you think of an American citizen like almost like a magic bullet, an American citizen has the ability, just by virtue of their citizenship, to help a number of what we refer to as immediate relatives immigrate to the United States. Um, so that would be a spouse, which is the common one, a child under the age of 21, and a parent of a U.S. citizen child that is over 21 years of age.
Okay.
Now, there is a misnomer in the world, really, that getting married is the easiest way to get into the United States, and I'd like to dispel that myth because it's not. Immigration. Marriage might provide a pathway for you to come to the United States, but we know that immigration and marriages are both tremendously difficult.
Mm.
And when a person immigrates to the United States, they have to go through three difficulties: marriage, whether it's a pre existing marriage or a new marriage. And similarly with immigration, America's a new culture. It
Mm.
took me a long time and it's taking me a long time to assimilate into the American culture. However, I came here with an attitude that I'm going to assimilate. I'm still going to
Right.
retain my identity, but I'm going to embrace the American culture, American values, etc. But I'm still essentially South African, and I'll always be
Right.
South African. Um, but people, make life-changing decisions without often without consulting a lawyer, And sometimes they can really destroy their immigration prospects or make their prospects of immigrating more difficult. Um, I've always believed that one shouldn't be too desperate to live in America. Otherwise, America won't really be kind to you. That you've got to come if you're coming on the basis of a relationship with an American citizen, your relationship with that person should be strong, because it will be challenged when you come
Right.
to America. And the process, the immigration process, builds that in to the whole petition process, and we can talk about that.
Sure. I mean, it's interesting for me that you say that you made a point of wanting to assimilate, and that's one of the things I think that we've found as well, is that I've heard of so many people that has come to the US and that has left again. And when
Yeah.
I try and understand that better, because if you're gonna be giving up everything in life and you're gonna move to a different country, you want to try and make it here. You want to not lose all your earthly possessions in the process. But there's some common things that I see a lot of people do, and that is they come here and then they want to hang on to only meeting with other South Africans. And I think
Mhm.
that's one of the things that I try to do differently. Our family, I mean, it helps. We're a family of five. So it helps that we kind of are each other's support system. But you're right. Assimilating is a key aspect of making a success here, right? Did you live anywhere else besides California? I mean, or is that where you
Uh,
lived?
no, we lived in Los Angeles for a year and a half, and then we now live in Orange County in a city
Okay.
called Irvine.
All right. Yeah, and I mean, I've been to California. I've been to San Jose. I've been to San Francisco. It's beautiful. It's amazing. It reminds me a lot of Cape Town, and I love it there. I just find Texas to be a little bit more like South Africa in terms of its people and its hospitableness, if that's a word. Uh, but let's chat about that. I mean, yes, I've heard a lot of questions on our group around, uh, you know, marrying an American is like an easy way, and you're right, that's a myth. The thing is that there's so many questions, like when do you marry someone? Like, let's just say you've been in a relationship or you've been living together, whatever your situation is. Like, are you let's deal with a question or some real questions that often comes up. There's situations where people have been um, they hear on a study visa. Let's talk about that. So if you legally in the United States and you here on a study visa, like when do you marry and where do you get married? Like what would you advise on that?
So, a student visa is an interesting kind of visa. Um, One cannot, at the outset, strategize to get a student visa for the purposes of immigration. A student visa allows you to do one thing, and that is come to the United States and study.
Mm,
Um, you've got to go to lectures, you've got to fulfill the requirements of your program, and then your student visa, your status is over. Now, if a person can apply for what's called adjustment of status within the United States, uh, based on a marriage to an American citizen, if one is a child under the age of 21, or a parent is present in America. So, with a student, um, if the student knew at the outset that they were going to come to the United States to get married, and then they did not inform the consular officer of their intention to get married, then that brings up a possible fraud, uh,
mm,
po- a fraud possibility that you're using the student visa to get into the United States, and then if so, but it doesn't mean you cannot apply for adjustment of status after a student visa. So one can apply for adjustment of status as long as one resolves the preconceived intent issue with the student visa, and that is that one didn't come here for the purposes of immigration and misrepresent that you are going to be a
Right.
student. And that's got to
It's like
be
that for every visa, though, right, Paul? I mean,
right. It
we got
is. It
to
is.
intent forms such an important or plays such an important role, right?
So you get some visas that are dual intent visas. So, for example, an E visa, which
Mhm.
does not is not available to people who only hold South African citizenship. But an E visa is a dual intent visa, meaning that a person can have the intention to immigrate and not to immigrate at the same time. And
Right.
that's not contradictory, and you're not penalized for that. Typically, what happens with a student visa is that a person comes here, enrolls in a university, completes, the university program, and while that person is at university, they meet a prospective spouse, and then they start dating. Now, that foreign student does not necessarily need to leave the country in order to pursue a green card. They can apply for what's called an adjustment of status, which is if you have a legal entry into the United States. In other words, you're admitted into the United States by a CBP officer or an immigration officer at the border. If you have that and you have a valid marriage and you don't have criminal problems and you don't have prior immigration issues, so then one could apply for adjustment of status as long as your spouse can support you. And if he cannot support you according to the Health and Human Services poverty guidelines, so then you can get a joint sponsor. Um, so, but often people, when people want to immigrate, there's this misnomer that they can just complete the forms themselves. And there are
Mm.
so many background issues that are not evident to a lay person who completes the forms. And then I often assist people who have denials for clerical reasons, for reasons that should not have been present. They didn't complete the affidavit of support properly, or there was a preconceived intent problem. Um, so
Do you find it's
adjustment
more
of
difficult to fix it if it was first done wrong?
So if a person's green card case was denied and they don't have an underlying status, so then they can be put into removal proceedings, and then they might be eligible to file adjustment of status with the immigration court. But that's a whole process,
Okay.
and not as easy as filing with USCIS. So when we talk about adjustment of status, it's not just an adjustment of status. What has to be filed is an I-130 as well. An I-130 is basically it's a petition for alien relative, and that is usually, but not only, filed by an American citizen on behalf of their relative. It can also be filed for of the benefit of people who are not immediate relatives.
Okay.
But we're not going to discuss that now. We'll park that off. Maybe we'll discuss it later.
All right. I
And
think
and the yeah.
I was just going to say that one of the things that strikes me is that there's often this perception that I don't need a lawyer. I can just do this myself. But that's one of the things that you've just touched on is that if you go onto the internet, it can seem as if you can take someone else's advice and apply it to your situation. But what I'm hearing is that everyone is unique.
Absolutely. And no one adjustment of status is the same. And also, what's important, and I alluded to this earlier, is how strong is your marriage? So, generally, a person will not have employment authorization at the time that they file for adjustment of status. That can come within 4 to 6 months, because together with the adjustment of status, one files an application for employment authorization. in terms of a particular section. I'm not going to tell you what that section is. But you file it in terms of that particular section, and then because you're filing for adjustment of status, so then you can get work authorization, which would allow you to work. In some marriages, it's really important that the spouse, the immigrating spouse, can work as well, and often they can't, and that can create tension in a marriage. And then you might decide, well, maybe it's not really a good idea for me to be present in the United States so they can apply for adjustment of status. Maybe one should be present. Maybe I should just stick around overseas, apply for my green card overseas, or apply for the petition for alien relative overseas, and then go through consular processing. And then one is granted an immigration visa. And then as soon as you walk into the United States with that immigration visa, you're considered to be admitted for 1 year as a permanent resident until the green card is issued and you receive that green card. If you've been married for less than 2 years, whether you get adjustment of status or a green card via consular processing, so then you'll get a conditional green card. And,
Okay.
and that's valid for 2 years. And the purpose of that conditional green card is really to test the stability of the marriage, because the only reason that you're coming to live in the United States is not because you love America. It's not America because you want the American dream and you've been dreaming to come and live here. If you put the American dream in your immigration forms, they're going to deny you, most likely. It's not a good idea. So the purpose of coming to the United States is always to be with your spouse.
Right.
Now we're talking about a spouse. And not because you're patriotic about America, and not because you love America and you want to live the American dream. It's almost like there's a concession that we're going to allow you to bypass the employment immigration pathway because you're married to an American citizen. And that's a concession. So they're going to test that. And part of the way of testing that, whether you're applying for adjustment of status inside the United States or filing a petition for alien relative and then going through consular processing, is the existence of joint documents. Because they are going to assume that if you have a good faith marriage, that you need to mingle your finances, you need to prove you live together, you need to prove that that this is not an arranged marriage for the purposes of immigration, because that is fraud, and if you do that, you're going to not be a happy chappy and possibly be banned from the United States.
Right.
And so, and then after 2 years, or just prior to the expiry of 2 years, one files a petition to remove conditions. And again, over there, one has to submit joint documents, just like one has to submit joint documents when filing for a marriage-based petition for a green card. They want to see that you live together, so you'll have a joint lease, joint bank accounts, joint utility bills. Most people think that, if I give a joint bank account and I fulfill the formality of a joint bank account and maybe a lease, things will be okay. My general approach is to flood them with joint documents as much as possible until we can't do that anymore, because then we're less likely to get a request for evidence for joint documents. And often, if a person does not have joint documents by the time that you get the request for evidence, you're not going to be able to provide those joint documents later. And often what I do is I tell couples, the joint documents that you have are not good enough. You need this, you need that, you need this, you need that. And then what happens sometimes is and it's particularly the case with older couples, is they want to separate their assets. They want to live life on their terms, not on the US government's terms. And that is also not a great idea. That can be accommodated to some extent, But ultimately, the test of a good marriage that the USCIS applies, or that the immigration services apply, is whether you live together and you have your lives are mingled.
I understand. So it's almost like it's almost like those married out of community of property that South Africans are familiar with is a luxury
Yes,
that you can entertain if both people are citizens. But if you want to get married to a U.S. citizen, there has to be proof that there has been comminglement. And
right.
am I understanding it right?
That's correct. So, in the United States, you'll have some states which have community property, and some states which don't have community property. And each state's community property regime is somewhat different to the other. So New York is an out of community property state. California and Texas, I believe Texas as well, I'm not a lawyer in Texas, is also not a community property state.
Right.
But we're not discussing family law. But even if one is immigrating to uh, a non-community property state, you USCIS expects you to mingle your finances.
But there's a lot of things. I mean, just as we're chatting about it, you can see that it's not simple. It's complex. And I mean, I just want to just take a step back. So why is it not a great idea uh, I'm just going to take some questions that I've seen being posted out there on the Facebook group. And people want to know, like, can I come to America? I've met someone. I would like to come and marry them in the US. Why is that not a great idea?
So I'm not saying that's not a good idea. So what we've been discussing up until now is marriage-based visas. And marriage-based visas, if one is present in the United States with a lawful entry, you can apply for a adjustment of status,
Can that
or you
lawful
can,
entry even be a visitor's visa?
yes. But
Okay.
we'll get onto okay, we can discuss the visitor visa now.
I
So
just want
there's
to, yeah, I want to pause there for
yeah,
a second because I almost
yeah.
feel like if you enter the United States again, with the intent of coming to get married here, um, isn't
So
that then like you couldn't do the adjustment of status then because you entered with that intent?
So yes, you can. So that a B2 visa is a legal entry. But
Okay.
again, as I was alluding to with the student visa, there's a problem of presumed intent. In other words, when you go to the consulate to apply for a B visa, you're essentially representing to the consular official that you're coming for non-immigrant purposes. If you if you file your DS-160 to get a B visa, and you come to the United States and you get married um, within 3 months, there is a presumption that you intended to get married at the time that you applied for your visa, but also at the time that you crossed the border. So when you're crossing the border with a B visa, you're telling the immigration officer at the border that I'm coming here for non-immigrant purposes. And if you get married or apply for an immigrant, and you apply for adjustment of status um, in the United States within 3 months, there's a presumption that you lied, and that could derail your entire immigration
Mm.
journey. Now, if you get married, like let's say a few months before, and then you come here on an immigration visa, there's a presumed intent problem. Okay. The typical scenario is that people come to or a foreign citizen comes out to the United States, gets married into the United States, and then applies for adjustment of status. Now, what happened under the Biden administration quite a lot is that people would do this. They would come out on a tourist visa, get married. Um, those who went to see a lawyer would get married after 90 days and then apply for adjustment of status. And usually those cases were approved without an interview if there were lots and lots of joint documents. Now, what's happening a lot under the Trump administration is that every case has an interview. They're not going to believe you on, generally 99% of cases will have an interview, and they're going to look into your immigration history, and they're going to see, well, you came here on a tourist visa. Did you have the intention to immigrate when you crossed the border, or when you applied for your when you submitted the DS-160 and appeared at the consulate for the interview? Did you have intention to immigrate? And sometimes you can overcome this presumed intent problem. There are ways that one can do that, but it's not a guarantee, and it's not something that's recommended. Now, if somebody comes to me um, uh, with the situation that they've applied for a tourist visa, that was granted. They come here, they get married after 90 days, and then they come to me and they say, Paul, I want to adjust status. I'll say, okay, we can file for the adjustment of status, but just know that presumed intent might be an issue. Now, if a person comes to me while they're still living in South Africa or some other country, and they haven't married yet, what I would do is not tell them to get a tourist visa unless there's some particular circumstance that can be relied upon, or some urgency, which we're not. There's infinite amount of hypotheticals, but I would advise that person generally, and I'm not giving particular legal advice to any person, was to apply for a fiancé visa. And that's the way
Okay.
that the government
It's a
wants you
K
to
visa.
apply for a visa. It's the K visa. So
Mhm.
instead of filing for a petition for alien relative, you file for a petition for an alien fiancé. I don't like the word alien because people from overseas are not from outer space, but that's just the term that's used in
It's
American
just the terms
immigration
on the
law.
forms.
Yes, it's just a term. It's not derogatory, but can be used in a derogatory way. But I would advise them to file the U.S. citizen to apply for a fiance, file a petition for a fiance uh, visa, which is an I-129F. Um, but then what happens where the U.S. citizen is present in America and the foreign citizen is present in another country, and they're not actually living together? So that's generally expected, that they're not
Mhm.
going to be living together, but there's a requirement of an in-person meeting within the last 2 years. And often people don't know that they have to have met each other within the last 2 years. Otherwise, the U.S. citizen does not qualify to apply for or to file a petition for an alien fiance. And then one has to prove in that petition, just like a marriage petition, but not exactly, that there is a bona fide or good faith relationship between the two of you. And you do that through text messages and through plane tickets and through pictures and through those sorts of things. Um, but I've never yet met somebody who's been able to complete the documents properly. I do a lot of these fiance visa petitions, and I've never found someone who's completed these documents properly. And often you get a request for evidence after that, either because you
Right.
haven't put enough evidence, you haven't disclosed, the U.S. citizen petitioner hasn't disclosed prior criminal convictions. Um, and you get requests for evidence, and then that request for evidence has a deadline, and sometimes you cannot get those documents, or let's say criminal records, or you can't create or joint documents or cause joint documents to come into existence um, with an institution or with WhatsApps, or you can't do that if you have a deadline. So always tell people who are applying for immigration, don't fight with your spouse on WhatsApp. Don't swear. Don't argue. Just say I love you. If you want to argue, do it orally on the phone. Don't swear at them. Don't be nasty. Just
So
don't say
funny because
the
I mean, it's
relationship
not
is
natural.
awful.
It's like relationships are just complex as well. Like marriage is complex, right?
Yes,
So I
exactly.
think it's natural to have that as part of. But it sounds like that might be held against you.
Yes, because right, it can be. So if you say the relationship's off, and then and then that's in the WhatsApp, um, exported file, that could be a problem. I always like to
Mhm.
put that exported file into the fiance visa petitions just as evidence, because it has dates and it shows that you've been in communication for a long time. I would also not, and this is not really legal advice, just personal advice, but don't do anything inappropriate in the text
Mm.
messages. Just
Because you need
keep
to
it
include it.
clean.
All needs to
Keep it
include it, guys. So
well.
don't
I'd like
put
to
those
include
pictures
it.
in there.
I'd like to include it, but don't. But if we can't include it, so then we can't. But it would be nice to include it, and then we've got a record of your relationship saying "I love you" every night. So that's helpful. So with a fiance visa petition, it takes around 9 months approximately to be approved. Then after that, one the foreign citizen spouse goes through consular processing, and assuming that they're admissible to the United States, and that's another topic probably for a different occasion. So, like if a person has crossed the border illegally and then left, or has overstayed their visa and is um, barred from entering the United States for 3 or 10 years, they will not get a fiance visa. But
Mm.
that's assuming they're admissible, they don't have any disqualifying criminal offences, and and the consular officer is satisfied there's a good faith relationship. So then the person will be granted a K visa, and then one has to leave your country with in by the expiry date, and then you come to America and you have to get married within 90 days. Otherwise, you will become deportable. Um, and then you apply for adjustment of status inside the United States. But because you were granted a fiance visa petition, you don't need to file a marriage-based petition. You just file for adjustment of status, but you've got to show that that you can be financially supported either by the sponsor, the main sponsor, or by the or by a joint sponsor as well. And the main sponsor has always got to be a sponsor, whether they can afford to sponsor you or not.
So a question we've had is, can a green card holder sponsor um, a fiance or a spouse?
So not a fiance. So a green card holder can file a petition for a spouse. It can also file a petition for a child, um, but not an unmarried child, but not a parent. Okay,
Okay. So when I
and
say a green card holder, so let's just say you are currently a green card holder, you have met a foreign national, and you would like to sponsor her for um, US citizenship, but I mean, you can't give what you don't have. So if you are not a US citizen, you can't give her your green card if you got married
so
after you got yours, or how does it work, Paul?
okay, so there's a number of preference categories, and I'm just looking in the U.S. visa bulletin. Every month, the Department of State publishes the U.S. visa bulletin, which really tells you when what's called a priority date becomes current. And so, for so there's four preferences. There's the first preference, which is unmarried sons and daughters of U.S. citizens who are over 21. Okay. Then the second one is spouses and children and unmarried sons and daughters of permanent residents, and those numbers are limited. Then, yeah, and then unmarried sons and daughters of permanent residents. I think I I'm repeating myself. So the F2A is spouses and children of permanent residents, and then unmarried sons and daughters of permanent residents. And then in the third preference is married sons and daughters of US citizens, and the fourth is brothers and sisters of adult US citizens. So what happens with a permanent resident is if is the person who's filing the petition eligible for citizenship? Because if they are, I would advise them to file for citizenship first, generally, and then the relative who would be a spouse in this case would be an immediate relative, and there are no limitations on the numbers of visas available to a spouse of a US citizen, but there is a limitation to the spouse and children of permanent residents. Now, the question is, can you apply for adjustment of status? And that's if you're married to a green card holder and the person is not eligible to become a citizen. And that is a complicated question. There was some time in 2023 that there was a current filing date for spouses of permanent residents, and that hasn't been repeated since I think it was July, August of 2023. And there was an option there at that time to file for adjustment of status together with an I-130 petition. But those adjustments of status that were filed at that time have not yet been approved. They are pending because the priority date, which is the date of the filing of the I-130, is not yet current. And so if you're going to apply for adjustment of status like present in the United States, you should contact an attorney. Most of the time, it's not possible. Sometimes it is possible, but it's really really complicated. If you're a green card holder and you're living in South Africa or some other country, well, there's an issue if you're a green card holder living in another country, but because you're supposed to be a resident of the United States, and you can lose your green card if you're living in another country, because there are rules about abandoning residency when you are deemed to have abandoned your green card or your residence. So yes, it is possible to file a petition for an alien relative if you're a green card holder. Generally, I would advise that person to do it while the foreign citizen is outside of the United States. But then if you do that as well, it's going to be difficult to prove your relationship because you're not essentially living together. And if you're living together overseas, then that's possible. But one should speak to a lawyer because the green card holder could lose their green card status because they're not actually residents of the United States. So it's a really complicated scenario, and we can't really get into specifics here. But yes, a green card holder can apply for the a spouse or um, um, a child under the age of 21, a child over the age of 21 who is unmarried. But it's more complicated, but it can be done.
Okay. So, well, I want to ask a question. I mean, if someone is currently legally in the United States, in other words, here under legal status, but they're married to a US citizen, and you do an AOS, an adjustment of status for them, what does that time frame look like? How long does it take normally?
So it's difficult to say. So at the moment, I would say around 4 to 6 months to get employment authorization, and about 9 months to a year to get an interview.
Okay.
But it depends on your location in the country. So if an interview is going to take place within the jurisdictional area of the USCIS office where you live, where you'll have to, prove that you have a bona fide relationship, and then you'll be able to, you'll be able to get your green card probably within 9 months to a year.
Okay. All right. And Paul, just a quick one. If people wanted to get hold of you, how do they do you have a website?
As I do, my website is wayburnelaw.com. That's WAYBURNELAW.com. Um, and you'll be able to find contact details for me at at the website.
And you're on LinkedIn as well. If people wanted to
Yes,
connect with
yes,
you, they can just
yes,
find you on LinkedIn.
yeah, yes,
Okay.
yes,
Well, in terms of there's some provisions against, or not against, in favor of women, uh, that's going through violence. Uh,
yes.
what is that? Tell me a little bit about that.
That's called so that's applying for a green card based on the Violence Against Women Act.
Hmm.
Now, and I always say, um, and I said it at the beginning of this podcast, is that one has to have a stable and strong marriage um, to go through the marriage based green card process, and also just to have a successful immigration. If people get married for the wrong reasons, or they get married to somebody they don't love, or they plan or they're scheming in their mind to use a particular US citizen to get a green card, chances are your immigration story will turn into an absolute nightmare. Um, and that's why I always say it. So often people get married and and yeah, they do it. They think they can love the person. They think it will be well, and then um, the dirt hits the fan, and the marriage goes south. And and it doesn't just go south in a in a in a in a way that's like okay, we'll just break up. No, it goes south often in a very difficult way, and particularly for women, because what happens is, the woman, usually the woman, not only the woman, sometimes men as well, but usually the woman, might not be the breadwinner and is reliant on the US citizen spouse to get their green card. Um, so the US citizen spouse has a lot of power in that regard. And so what that um, has a lot of power, and the US citizen can use that power to coerce the foreign citizen, to coerce them
In
in
that
ways that are not
relationship,
appropriate.
is that what
So,
I'm hearing,
so
is that
often,
there's some kind of a protection for people
so there
who
is.
is.
So if a person uh, got married in good faith and not for immigration purposes, and they were subjected to extreme battery, then they could apply for a VAWA, which is an I-360. That's the form where you apply for status independent of your US citizen spouse, and that's available to people who had a good faith relationship and also were subjected to extreme cruelty and battery. Battery is the US term for assault in South Africa. Um, so battery is like touching, but it's got to be extreme. So if a person had, so if, forgive me for saying these things out aloud, but if a person is getting punched and kicked and smacked across the face and they have bruises, and they go and see they go to the police and uh, they go to the police and they go to other to the hospital, and there's medical records and there's photographic evidence, so then one can build up a case for a VAWA. But often you don't have those medical records, and then it's like, oh, this is what my husband or my wife financially abused me, and that's a lot more difficult to prove. But if one has sort of been beaten up, so to speak, and you've got actual physical evidence, then you can get a VAWA. But it's no guarantee that it's going to be granted. Um, and so one. a vow is kind of nice if you're. It's like it's good for you if you have that option, but
Mm.
it can. You firstly, you may not get it, and secondly, it's an extremely terrible option to plan for that at the outset because probably your
Right,
vow is not going to work out,
right.
and you're going to have a hell of a time in that marriage. Um, and it's I don't recommend it. Don't love America too much.
Yeah. No, I agree. The reason I brought this in is because last year there was a situation that I became aware of a marriage that ended uh, terribly. I think both parties died, and it only transpired later on that people were aware of the fact that the woman literally stayed in the relationship until the last moment because she believed that she had no other options. That was a terrible marriage. So I
Yeah,
just wanted to touch on that because I feel, even though it's extreme and the onus of proof is hectic, one should always talk to a lawyer because there are always options. And I think that's the key is that when you try and resolve these things on your own, it's complex and it's difficult, but always seek legal advice early on, and try and avoid mistakes. Well, I wanted to
that's
just, before we
yeah.
wrap up, I wanted to ask your opinion on, I mean, you've heard everything that's been happening with the, and I'm kind of ambushing you here, um, about the refugee status and South Africa and all of these new things. Where are you on that? What is it that you think? I mean, first of all, I want to highlight the fact to the listeners that there is a difference between applying for refugee status and applying for asylum because the two are kind of used interchangeably on the internet, but there is a big
Right,
difference.
right.
Asylum you can only apply for from within the United States if you're already
That's
here,
correct. Yes,
and refugee status you can only apply for while you are outside the country. In other words, you do it from the country in which you are trying to flee. So
correct.
be mindful of that when you're using those terms, guys. When you are asking for advice, avoid. South Africa has had a very very terrible track record in trying to use asylum. There's always someone who knows someone that has a cousin who got entered or got asylum in the US. The reality is that very few of those cases have been successfully processed. Anyone can apply for asylum, um, but you're not allowed to work while you're here during that process. And very few of them actually end up being processed successfully. Personally, I've never met anyone that's had that happen. But I wanted to touch base on the refugee thing, or like, where are you with that? I mean, do you think it's a good idea?
Um, so I try and um keep it distant, like a personal boundary between myself and and what's going on in the media,
Right.
and to be guided by dramatic media, because it can overtake your life. But I do keep myself informed of the refugee status. Now, I believe that there are arguments that can be made for particular individual South Africans to qualify for refugee status. Um, I I have not, this is I've dealt mostly with asylum. When I've done when I've dealt with people in the refugee asylum uh, categories. Uh, but I've been giving a lot of thought to the issue of Afrikaans refugees. Now, I believe that there is an argument for some people to claim refugee status. I don't know if all the people that are getting refugee status actually qualify for refugee status, um, but you can try. There's nothing wrong with trying and seeing if you get chosen, or you're persuasive enough. What I do know is that you've got to show that whether you're applying for asylum or whether you're applying for refugee status, you have to show past persecution, or in um, past persecution, as we would say back in South Africa. But so you have to show past persecution, and past persecution has got to be something that's extreme, that is usually perpetrated by government actors, or by groups that the government is unable or unwilling to control. So I could imagine that in many rural areas where there are Afrikaans farmers, that they are not afforded equal protection of law, and that crimes against some Afrikaners have not been taken seriously. And that could form a basis for a refugee case. So even though the crime was committed by criminals as opposed to the government, the fact that the government may or may not be giving you equal protection of law, i.e., police services, or that these areas in rural South Africa are not, um, let's just say, places where the rule of law exists. So then there is an argument that can be made for past persecution. My understanding is that, in the refugee cases, people have been given refugee status when they may not have suffered past persecution. Um, but I cannot speak with personal knowledge on that. I don't know
Mm.
whether they do or whether they don't. But I imagine that some of these refugees who are making it to the United States have suffered past persecution, and some may not have.
I'm here on the U.S. Embassy and Consulates in South Africa's website, Paul. And if listeners wants to Google that, they can Google refugee admissions program for South Africans, and it deals with the executive order 14204 from President Trump um, from earlier this year, and it gives three eligibility requirements. It says to be eligible for U.S. resettlement consideration, individual must meet the following criteria. One, you must be a South African national. You must be an Afrikaner of ethnicity and or be a member of racial minority in South Africa. And, so this is an and, must be able to articulate a past experience of persecution or fear of future persecution. And so, I mean, these things are here. I have a personal opinion on it, and let me bounce it on you. Let me hear what you've got to say about it. My personal opinion is that if you really have no other path of legal immigration to the United States, and I really mean no other, no, this is a last resort for you, and you are a South African national, and you are of Afrikaner ethnicity, or you're a member of the racial minorities in South Africa, and you're able to articulate a past experience of persecution or a future persecution, fear thereof, then this may be a credible route for you to take. My concern would be that if you're going to put your name down on a list and you actually have another viable option to get to the US, you're going to declare that you have a desire to be in the United States. And I'm concerned that at a later stage this may be held against you. What is it that you think? What do you think about that?
So, I mean, it may be. We don't know what the future holds. One should, if one is going to pursue the Afrikaans refugee status, make sure that everything you tell them is the truth.
Right.
And don't embellish it to such a point. Don't embellish the alleged persecution to such an extent that you're not telling the truth.
And to that point, everything that you ever say to any in any of your applications should always be 100% the truth. I just want to put that out there.
Absolutely. Absolutely.
Assume that you never get asked a question for which the border patrol officer or the person that's dealing with your immigration case does not already know the answer for. And so when people are asking you a question, assume they already know the truth. They already know what that answer is.
Yes. Yes. So
Sorry, Paul, I
I,
interrupted.
I'm sure a lot of Afrikaners who have come here as part of the refugee program, will have successful immigrations. I don't foresee uh, um, that a subsequent democratic administration is going to take away their refugee status because it was validly granted under the law. And I don't think they're going to just strip them of it. And then, in any way, the refugee would be able to apply for a green card after a period of time anyway. And then they wouldn't be, I don't think a future administration would kick them out. But for a lot of Afrikaans people, this is the only viable way for them to come. They're not going to find a job through an American employer who's going to sponsor them and go through the labor certification process. And this is really a once in a lifetime opportunity for a lot of people. So I wouldn't tell people, not to do it. Keep your options open, but just don't
Okay.
lie in that application. Don't ever tell a lie. Um, and so like go for it if that's what you want and that's your only viable pathway, but don't expect America to be easy. It's not easy, and you might have to do work that you don't otherwise enjoy, or that might be damaging to your ego, or um, it might not be so pleasant. And then I've been listening to some of the podcasts and some YouTube videos, and there are influencers out there who are inciting against, Afrikaans refugees. I don't believe that. I respect everybody. I respect everyone, um, and so just come to America with your eyes open if you're coming into as part of the refugee program.
Yeah. I mean, lawyers typically don't um, have a lot of influence when it comes to refugee programs. That whole process has always been managed end to end between appointed US non-government organization and the United Nations. But I mean, that whole the official refugee
Right.
processing, has actually been shut down, and I think that's what a lot of people
That's
don't
correct.
realize.
Yes, that's correct. It
There's
has
there's
been
a
shut down for the most
there is
part.
an executive order around the same time as 14204 came out that actually shut that whole process down. So I think there's a lot of uncertainty as to how it's being handled at the moment. There is the United States Embassy in South Africa is still got a link on their website that says the statement of interest form can be accessed at the following link. And so there is a statement of interest form. Um, so it's interesting for me, and I value your input, and I like the angle that you're coming from. You saying if you can do it, do it. I'm a little bit more cautious. I'm like, I don't know. Um, there's been a lot of hype around it originally, and then it all kind of like has gotten quiet. I'm only aware of the original 54 people that's landed in the
Yeah.
US. Um, but I also understand that those that have been affected have been asked to to not speak out to the media. So it's an interesting one, and I think we want to invite people, if you have any additional knowledge, to reach out to us. I really do want to encourage you, if you would like to uh, gain more information or an understanding of how your own immigration journey can look like, and you need some input. Reach out to Paul, because it's so difficult to just find information on the internet and apply it to your own situation. Every single thing. And be transparent. Reach out, schedule an appointment. I'm pretty sure that these are billable, right, Paul? I mean, you'll
Yes, yes,
yeah.
yes.
I mean,
So, I mean,
schedule an appointment with Paul and ask your questions. I think at the price it's cheap. I always feel that getting the right information early on can help you and maybe put you on a different path as opposed to going down one and then later finding out that the ladder that you've been climbing has been set up against the wrong building.
yeah,
So
yeah,
get it done right from the beginning. And Paul, I really value your time that you've spent here with us today. I think we should have another podcast. It just seems like we've only touched on one area
yeah,
today, and there's
yeah.
so many of them.
I
There's a
mean,
lot to talk
yeah,
about.
there's a lot, and immigration law is vast. Even just in family immigration law, it's vast,
Mm,
and and then one can discuss citizenship and then commercial immigration, and it's a vast area of law.
right.
Um, and
But I think listeners,
ChatGPT, right?
if there's a specific topic that you would like to hear from Paul on, um, make contact. It's and then I'm happy to have you back here and we can discuss that topic.
I'd love
That'll
to
be an
come back.
interesting one.
Thank you. I'd love to come back.
Good. All right, guys. Paul, again, thank you to you. And for all of you, you can visit the South Africans immigrating to or legally immigrating to the US forum on Facebook. You can find the Citus. It's the SAITUS, which, if it's an acronym for South Africans immigrating to the US, that's a co.za website.co.za for my South African compatriots. And let us know what it is that you would like to hear about. We're happy to talk to you about that. Great. Until next
Thank
time.
you.